Good afternoon. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. And today we're having a recap of the most important immigration news we received during this past week. Well, first of all, of course, I think that one of the most important decisions we need to look at, court decisions in immigration we need to look at, is a decision coming from the Ninth Circuit, Gonzalez versus USCIS, where the court held that ICE has to have probable cause or has to demonstrate probable cause just the same way as the police does at the time of the arrest or shortly after. So it's a quite important decision. Of course, it would be revolutionary for the whole immigration system if it stays, but that's something that you need to be aware of because it's basically going to change the whole framework of how ICE works and operates, and perhaps it will affect the entire removal proceedings, okay? Because probable cause in criminal law is the point from which we can state whether arrest was justifiable or not. And if it was not, then the person often may be free of charges if the arrest was not justifiable. So if the same framework is going to be applied for immigration cases, as you can imagine, it will change the way the immigration cases are being dealt with in courts. Another very important and perhaps the most disappointing decision that came out this week is a decision in the matter of Panda versus Wolf, coming from the DC Circuit, stating that unfortunately H1B seekers of the H1B visas from India would not qualify for the preliminary injunction. So the lawsuit is about the following situation. Let's say somebody was in the United States, a national of India, was in the United States in a lawful non-immigrant status, left the United States for a variety of reasons, and now he or she would require an H1B stamp to come back to the United States. But Presidential Proclamation 10052 happened that prohibits H1B visas to be issued. So there was a class action filed by over 160, I believe, persons who were representatives of the class, and the court held that plaintiffs wouldn't be unable to prevail on merits, unable to show that the harm they're trying to prevent is going to be a new harm, and the harm has not happened. Because to prevail on the motion for preliminary injunction, a person has to demonstrate that he or she has a likelihood of success on merits, basically will win the lawsuit in the end, and that he or she will suffer harm that cannot be addressed, cannot be repaired if the preliminary injunction is not approved. And in this particular situation, the harm was potential loss of job and inability to come back to the United States. And the court stated that you already have this harm. Basically, what new harm are you going to be talking about in case you cannot come back to the United States? And of course, what didn't help in this situation was the Gonzalez case that was decided a little bit earlier, where plaintiffs for immigrant visas could not prevail. Most of the plaintiffs, except for DV lottery beneficiaries, could not prevail in a preliminary injunction challenge motion. And unfortunately, that's what we have with Panda versus Wolf. So no relief for Indian nationals seeking to come back to the United States on H1B visas. Then, of course, remember that National Benefit Center is laying off quite actually significant number of their employees, 800 people, USCIS stating that it's happening because the applications amount of the filings is significantly reduced, about 50%, I believe they stated. Hence, the government, USCIS, is not receiving fees and cannot sustain all their employees. 800 people is a lot of people to lose, as you can imagine. I believe that it cannot not cause delays. So that's another sad news that we received recently. And now a little reminder, just remember, starting from October 2nd, new USCIS fees are going to kick in. Most of them are going up significantly, but what all else is happening is that it will be harder and in certain cases impossible to receive a fee waiver unless you're an applicant for certain humanitarian reliefs. Also, some forms are changing. For example, forms I-129 form that previously was used for various types of visas statuses now is going to be replaced by separate application forms. Premium processing is changing. Now, I believe the fee is going up a little bit for premium processing, but also now USCIS, if you file premium processing, is going to take 15 business days to make a decision as to what they're going to do with the application or petition. Not 15 days, 15 business days, which increases, of course, the time they will take to make the next move. As you know, with the premium processing, it's either going to be denial, approval, or a request for more evidence. And those are the main news that I would like to highlight in this little presentation. So important federal court decisions, cutting staff in the key USCIS offices. It's very, very important. National Benefits Center is the place that basically decides a lot of family-based petitions. It's one of the key place where applications are being sorted out and decided. And of course, don't forget about the incoming fee changes, October 2nd. That's a very important deadline. So thank you very much for watching. Please subscribe to my channel if you like to receive most up-to-date immigration news and information. Like, share, and I hope to see you soon.